Arbitrators can end your career. What do I mean by that? Arbitrators don't got to get it right in order for you to get fired. Let's take my case for an example. The arbitrator was not weighing the facts, was believing the lies of the witness, Vikram Sowinda, even though he contradicted himself. Um, the MTA contradicted themselves in the briefs. Vikram Sowinda contradicted himself in the testimony. And the arbitrator didn't get it right. And the arbitrator ended my career. And what makes it harder is that if I try for Article 75, the scope is so narrow to overturn an arbitrator decision. Now, I know people be thinking, they be thinking that this is Matlock, CSI, Kojak, Hunter, whatever the case or show it may be, that, logically, this don't make sense. This don't make sense. How can they do it? How can they rule against you? You can have an appeal, this and that. I'm going to give you guys some information to show you how an arbitrator can wrongfully end your career. And I want you to check out this case law right here. I have it underlined for you. It says it blatantly. You see it right there. Even where an arbitrator has made an error of law or fact, courts generally may not disturb the arbitrator's decision. So you mean to tell me that an arbitrator can make an error of law and fact and not be held accountable? An arbitrator can make an error of law and fact, and you cannot challenge that arbitrator's ruling in an Article 75. In fact, there's no court that you could challenge an arbitrator's decision if they made an error of law or fact. How about that? How is that even possible or permissible? In regular court, if a judge make a error of law or fact, there's an appeal process that it could go to. For some reason, the courts do not want to touch arbitrator decisions, even if there's an error of law or fact. So, Tramel, how can you challenge, or what basis can you challenge an arbitrator's decision? Let me give you guys the language for that. And I want you to understand what's being said to you right now. Of these three narrow grounds that may form the basis for vacating an arbitrator's award, that it violates public policy, is irrational, or clearly exceeds a specifically enumerated limitation on the arbitrator's power. Those are the only ways that you could get an arbitrator's decision vacated. It boggles my mind as to why unions didn't lobby or don't lobby to change this law. Now it could work both ways. The MTA, they challenge arbitrator decisions. Unions challenge arbitrator decisions. But I personally think that arbitrators, they got too much power, especially when someone's career is on the line and things of that nature. How can you make an error of law and fact and that cannot be challenged? There has to be some type of resolve for these type of actions, because I just don't get it. And so many people lose arbitrated decisions, and when these decisions are made in lieu of error of fact, the grievant don't have no recourse whatsoever. And it's messed up. It's messed up. So an arbitrator can wrongfully end your career. They could go in there, they could uh, misinterpret the law, they could misinterpret the facts, like what happened in my situation, and there's no repercussions for it. There's absolutely no repercussions for it. They could do what they want to do. And what I want to tell you guys this too. I think for appeal purposes, um, especially if you don't trust the union or you don't believe in the union, I think that you should represent yourself in these cases. For the simple fact that if you do decide to appeal it, you don't have no standing, right? Oh, Tramel, what do you mean? I was a part of the arbitration. It's my arbitration. I have to have standing. No, if you look at the arbitration award, it's the union versus the MTA or whatever the case may be. Especially, I'm gonna stick to our sentence. It's the union versus the MTA, right? It's not Tramel Thompson versus the MTA. It's the union versus the MTA. And the only way, well, I'm gonna tell you what the importance of that is. If you decide to raise an Article 75 claim, the union basically have to approve you challenge it in the court, right? Or if you could prove that the union breached their duty of fair representation, then there's an opportunity for you to represent yourself in court after an arbitrator decision award came down that wasn't favorable of you, right? So just to be clear, if you don't have faith in the union and you plan on wanting to arbitrate your case outside in court and you thinking that you're going to get fired, I advise you to represent yourself, or get an attorney to represent you. Don't use the union attorney at all because there's a chance that they may not want to give you the opportunity to challenge in court, because you don't have no standing. I know all of this sound crazy, but it's facts. It's facts. You don't have standing if you allow the union to represent you in arbitration. That's right. This is a strange, strange system that we in, but the more that I learn, the more that I go through, the more I appreciate it because I get the opportunity to help you guys out. If you like what you heard, you could donate to the channel right there via Cash App, Progressive Action 100. I'll catch you guys later. Peace.